Not long after the death of a family member, the reality of probate sets in. The looming probate process can feel overwhelming for a first-time personal representative. After all, probate is a complicated and protracted legal process that involved noticing parties, discovering assets, transferring property, and paying debts. To make matters worse, the system remains mired in ancient terminology and ambiguous distinctions between classifications of property. Few would not feel overwhelmed facing probate for the first time. This video seeks to answer a few of the questions a first-time personal representative might ask at the beginning of probate. Do I need to probate my family member's estate? In Maryland, probate requirements can vary depending on the specifics of the estate, including the size of the estate, the existence or absence of a will, the nature of the estate beneficiaries, and whether the decedent had creditors at death. Generally, probate is required in Maryland to settle estates unless all the assets of the decedent were held in a trust, held jointly with right of survivorship, or set up to pass by beneficiary designation pursuant to a contract. For example, the decedent might have had beneficiaries designated under one or more life insurance policies, or as payable on death beneficiaries with an investment bank. In those cases, the insurance proceeds or investment account balance would be non-probate assets. However, if the decedent owned any property solely in their name, or had any assets that did not automatically transfer to a surviving joint owner or beneficiary, probate may be necessary. The only probate assets in the estate might be a car or a single small bank account for which the decedent never thought to name a beneficiary. Regardless of how insubstantial the assets, probate is necessary to transfer those assets to the heirs or legatees, what heirs are called when there is a will. In Maryland, probate involves filing paperwork with the Orphans Court in the county where the deceased person lived at the time of their death. This process allows for the legal transfer of assets to beneficiaries and ensures debts and taxes are settled. That being said, if the funeral costs have absorbed all the assets of the deceased person's estate, there may be no need to open a formal probate estate in Maryland. A common question we get is asking about a small estate. In Maryland, there is a simplified procedure for handling small estates. If the value of the deceased person's assets is less than $50,000, again, excluding exempt property and assets that pass outside of probate, the estate may qualify for expedited small estate administration. This involves filing a petition with the Orphans Court and providing documentation such as an itemized list of assets and their values, a statement of funeral expenses paid, and an affidavit stating the relationship of the petitioner to the deceased. If funeral expenses were paid directly from the deceased person's accounts, such as from a payable on death account, or by a third party, such as family members or a prepaid funeral plan, this may further simplify the estate settlement process for a small estate. Another common question we get from family members is asking how long the probate process in Maryland takes. The duration of probate in Maryland can vary depending on several factors, including the complexity of the estate, whether there are any disputes among beneficiaries or creditors, and whether the court docket is backed up. Here are some general points to consider regarding the timeline of probate in Maryland. Point number 1, the initial filing and inventory. The probate process typically begins with filing the necessary paperwork with the Orphans Court in the county where the deceased person lived. This includes submitting the will and an inventory of the deceased person's assets. The timeline for this initial phase can vary, but it generally takes 1 to 2 months. Point number 2, notice to creditors and claims. Period. After filing, the personal representative, executor, must notify creditors of the estate and publish a notice in a local newspaper. Creditors then have 6 months from the date of the first publication to file claims against the estate. Point number 3, resolution of claims and debts. The personal representative is responsible for identifying and paying valid debts of the estate. Resolving these claims can take time, especially if there are disputes or if the estate's assets are complex. Point number 4, distribution of assets. Once debts, taxes, and administrative expenses are paid, the remaining assets can be distributed to the beneficiaries named in the will or heirs, according to Maryland's intestacy laws if there is no will. This distribution process can occur once the court approves the final accounting. Point number 5, closing the estate. The final step involves closing the estate, which includes filing a final account with the court detailing all financial transactions of the estate. Once the court approves the final account, the estate can be closed. On average, probate in Maryland typically takes 9 to 12 months to complete, depending on the specific circumstances of the estate. Complex estates or those with contested issues can take longer. Working with an experienced probate attorney can help streamline the process and ensure that all legal requirements are met efficiently. Another example of a common situation is when the orphan's court clerk tells a family member that they might need to open an estate outside of Maryland, and the surviving family is confused and doesn't understand why they would need to do that if the decedent lived in Maryland. Ancillary probate refers to a legal process that may be required when a deceased person owned property in a state other than their primary state of residence. If someone is suggesting that you should open an estate outside of Maryland for your relative who was a Maryland domiciliary, they are probably referring to ancillary probate. Each state has its own laws regarding probate, so whether another probate estate is necessary really depends on the rules of the ancillary state. The purpose of ancillary probate is to ensure that the out-of-state assets are properly transferred to the rightful beneficiaries or heirs according to the laws of that state. The process typically involves appointing a personal representative, executor, in the ancillary state, filing necessary documents with the local probate court, and following that state's probate procedures. The procedure for ancillary probate can vary depending on the state involved and the specific circumstances of the estate. Generally, it involves providing proof of the primary probate proceedings, filing an authenticated copy of the will, and inventorying the out-of-state assets. For specific guidance on whether probate is required in a particular case in Maryland, consult with a qualified attorney who specializes in estate planning or probate law. At Paré Associates, we specialize in probate administration and can provide advice tailored to the individual circumstances of the estate in question.